So good afternoon to everyone. My name is Sharon Hecker. I'm the chair of ICRA, the International Catalogue Raisonné Association, and I wanted to welcome you all. Also on behalf of our wonderful board, Matthew Stevenson, Alex Morrison, Sarah Davis, and Edith Devaney. This is the second joint ICRA and ALA, the Art Lawyers Association, joint spotlight. The first one was incredibly successful, and we got so much positive feedback that we decided to do it again and bring back the lawyers that spoke on the panel last time. This time we will be dedicating this spotlight to a very thorny legal issue surrounding catalogues raisonnés, which is whether to authenticate or not. Many of our authors, artists, consultants, lawyers, and estates have questions about this. And we really didn't have time to get into the topic last time during the previous spotlight. Is it enough to just write a catalogue raisonné? Is the authenticator different or the same figure? Many of our members are no longer authenticating or giving certificates of authenticity, and some lawyers are no longer advising their clients to authenticate artworks. So why? What is at stake? On the other hand, there's many who still believe that it is the way to go and that these authentications are needed for market purposes. So we wanted to know if there was a shift going on in the field, if there are any landmark cases that can help us think about authentication. Where does that leave our catalogue raisonnés and their authors, including artists who are preparing their own catalogue raisonnés? Today, we have quite a large number of people who are signed in on this Zoom, so it suggests to us that we've hit on an important topic. We basically want to discuss and raise questions more than bring answers to the questions today. So basically, I wanted to say that one of my goals as chair has been to try to better connect the world of art historians and those engaged with catalogue raisonnés with the legal world. I think that there's a very productive intersection between our two fields, and that any dialogue we can have can be very mutually beneficial and actually help shape new directions in our thinking in our respective fields. We have an amazing lineup of speakers today. We want to first of all thank our esteemed panel of art lawyers from different jurisdictions. From the UK, we have Amanda Gray, who is a partner at Mishcon de Rea and also the chair of the Photographers Gallery. From the United States, we have Stephen Schindler, who is the founding partner of Schindler, Cohen, and Hochman in New York. And from the European viewpoint, we have Pierre Valentin, who is an art lawyer and the founder of ICRA, and basically we wouldn't be here today if it hadn't been for his vision 6 years ago. So we're very happy to still have him with us. I also want to mention ICRA's 6th annual conference. The theme you can look up on our website. It has to do with new thinking about catalogue raisonnés, and it will be held on January 9th at Mishcon de Rea in London. We have a truly fantastic lineup of panelists and speakers, and we're going to be announcing them very soon. Please consider registering or coming live or through the online streaming. These kind of events really help to support the high quality of content that ICRA is now well known for. Our past conferences are all now available on YouTube on our website, so you can watch them again. And we really would ask you to please consider becoming members of ICRA. We're a nonprofit membership. We are completely grassroots. We try to bring together people involved in catalogue raisonné work, as well as people who use this tool in their daily practices. We depend highly on our membership for support, and you can contact Emily Gasparo, who's up in the left in the blue sweater, for more information. We even have a special area now dedicated to art lawyer memberships, and we've begun to see an uptick in art lawyer memberships. So we're very happy about that. Just a few housekeeping rules before we begin. You know, we are being recorded, And we have gathered all of your very interesting questions, and we will be asking the lawyers to comment on them. You're welcome to put things in the chat that come up to your mind. We can't promise to get to everything, so we will try as much as we can to go through some of these questions, which have been extremely interesting for understanding where the field is going as well in terms of what things are interesting and important to you. Okay, on to our panel. So the first, I think I would like to start with Stephen, if that's okay with you. The first question, which many authors of Catalogue Raisonné would like to know about, is what kind of protection can a Catalogue Raisonné author take or an authenticator take in the US to protect themselves from lawsuits? And maybe is there anything they can do apart from just obtaining a signed submission agreement where the owner agrees to pay the legal fees? And please, other people also, Pierre and Amanda, if you feel free to step in from your jurisdictions as well.
Sure. Thanks, Sharon. Well, you've sort of hit on the main thing, which is a signed submission agreement that allocates attorney's fees to the winner of any lawsuit, because that is the most important thing that you can do. But just to take one step back for a second, I think the law in the United States, and I'm focusing mostly on New York, is and has always been very favorable to authors of catalogs. Even going back to, we have an appellate case back in 2009, which was the case of Joel Thome against the Alexander Louisa Calder Foundation. And one of our appellate courts in that case basically said that there is no legal right to have anything included in a catalogue raisonné. And the creation of a catalog is a private enterprise, a voluntary act. And so we're not going to step in and force an author to include or not to include something. And then back in 2019, we also had a very good case, and this did involve a submission agreement. It was the Mayer Gallery versus the Agnes Martin Catalogue Raisonné, in which all of the claims that the gallery brought against the Catalogue Raisonné were dismissed. But in addition to that, and this is where the risk has always been for catalog authors, I think, in the United States, is that unlike Europe, we do not have generally fee shifting laws, something called the American rule, where basically everybody has to pay their legal fees. And the reason why the allocation of attorney's fees is so important in a submission agreement is that very often catalog authors are successful, but that's the good news. And the bad news is, here's your legal bill, which is why having the submission agreement with fee shifting, contractual fee shifting, is so important. And the only other thing I'll say, and then I'll stop, is that I was curious because I hadn't really, although we've been involved with some authentication issues, I hadn't heard of any major cases in the United States since the Agnes Martin case in 2019, which went, in favor of the catalog authors, and I haven't found any. And so, to some extent, the legal landscape has been very quiet in terms of lawsuits against Catalogue Raisonné authors here.
That's interesting. I didn't know that things have quieted down. Pierre or Amanda, either one, do you have any? Pierre, you're muted.
Yeah. Similarly, in terms of a Catalogue Raisonné over here, it's obviously interpreted facts. It's deemed to be an opinion, and similar position in terms of cases against Catalogue Raisonné. We look at the authorities. The leading authorities seem to be in the US. So the Agnes Martin case that Stephen has alluded to, and also in terms of France as well. But in terms of claims, I know this is one of the questions that somebody asked, which shows people are concerned about what are their exposures if they are the author of a Catalogue Raisonné. There aren't really any sort of live ones or ones that are recent in terms of against Catalogue Raisonné in the UK, because you will be looking for a loss. You'll be looking for, if you're bringing a claim, you're taking the steps of very expensive litigation within the UK, and it is considerable, you'll be looking for a loss initially. And unless a catalogue raisonné has some other interests and they should be, independent, etc., there won't be that there.
That's fascinating. And that goes to a question that we were going to bring up later, but it is an important question. Is the Catalogue Raisonné a record of a fact or an opinion?
Yes, no, absolutely. And you're looking at, we'd say it's based on facts, but it's interpretive facts. You have well, we can talk about AI to some degree, and that might be a part of the future developments, etc., as one of the tools in the box, etc. But it is interpretive facts. It depends on who the author is for the catalogue, for the actual catalogue raisonné, etc. But you're looking at, say, the oeuvre of the artist. We talked about it last time, the list of the works they're created. But there is fluidity within that, in what works are included, what works aren't included. There are obviously question marks about that, and that's where a lot of the issues arise. Are things excluded or not? And what is the implication when that catalogue raisonné is then used within the art market? Whether it's referred to in an auction catalogue or it's not, or what happens then. And it's that thorny intersection when you will get the loss scenario arising, because it's being used for a different purpose that it might have otherwise been generated for, i.e. by an art historian or somebody who is part of the art world, but not necessarily thinking that their work is going to be used as a tool within the art market as a due diligence documentation or some other validation for the work that will ascribe a value to that work.
Yeah. Pierre, do you have anything to add from the European viewpoint on that? You're muted.
Mute. Here we are.
There you go.
Hello.
Yep.
Do I have anything to add from a European perspective? I think, yes, I would say that in continental Europe, the courts tend to take a much more black and white approach to whether an artwork is authentic or not. And in Europe, we have this problem, if I can put it that way, that it is an element of civil procedure that you have what we call court-appointed experts. In the UK and in the US, the court doesn't appoint experts. The parties appoint their experts, and the court listens to the parties' appointed experts. Whereas in France, Italy, and other countries on the continent, it's the court that appoints the expert. And the issue that comes with that is the court-appointed expert is basically God. Whatever the court-appointed expert says is the truth. And that's where the black and white comes in. It's what he or she says that counts, not the whole of the moral rights or the expert, the real expert on the artist or the author of the Catalogue Raisonné. And for me, that's a problem.
Yeah, because sometimes the court-appointed expert is not the world expert on the artist.
Absolutely.
We already have 3 very interesting comments and questions in the chat, so I will just throw them out there at you. One person wanted to know about having professional insurance to protect CR authentication activities, if that's something that the legal world advises. Does somebody want to take that up? Is that a good idea? Not necessary. I mean, I guess, Stephen, you were saying that the US kind of protects them, so you might not even need that.
Well, I think and Hack, I think in the other in one of the other chat boxes mentioned errors and omissions, which can cover this. There are policies that authenticators can take. My experience is that they're very expensive, and one of the issues that we've always had is a kind of asymmetry between the fees that someone or the payment that someone who's authenticating a work, an expert gets, and the value of the work and the risk. So there's a big discrepancy between the fee and the risk, right? If you're authenticating a work that is very, very expensive potentially, and there are people with means who are sort of counting on that authentication, and you're getting paid, a few $1,000s or whatever it is to do the authentication, you're putting yourself at a certain risk for not a huge reward. And then to add on top of that, paying for insurance, that can be very expensive. Again, if you're part of a big institution, that's different. If you're smaller, then that's more complicated.
I think to add to that, I think there's a distinction also, and we have to be, and it's come through in a lot of the themes of the questions, that there are Catalogue Raisonné, people who author them. Sorry, I've got a terrible cough. Catalogue Raisonné. Then there are also people who are authenticating bodies or authenticating individuals who may or may not overlap in terms of doing both, but they might be distinct. Excuse me. And there is a distinction between both. And then within that, there may be people in terms of authenticating, that they are authenticating for a specific project or purpose, as opposed to creating a Catalogue Raisonné, which is itself as something else entirely, though it feeds into, of course, the authenticating process. If you are authenticating, say, a work, and somebody talks about methodologies, absolutely, I would be setting out my methodology, the scope of my work to narrow my liability at the outset of that document, in order in some sort of protective way it helps. However, certainly in my jurisdiction, there is not a body that regulates that. You don't have a set template that everyone follows, so you're not comparing pairs with pairs. So you have a problem there that it might be disparate in terms of what you're looking at, and it also doesn't stop claims being brought against you potentially. Say, for example, if your authentication document is in support of validating some works that are within for a sale or for a fund, and that all goes wrong, it doesn't stop you being drawn into that litigation nevertheless. Similarly with Catalogue Raisonné, it's a slightly different set of criteria, but I do think if you could set out how you reach your conclusions, etc., that can be no bad thing in terms of that document, or why certain things are in, or why certain things may be out, or still in limbo, as it were, or in process. I think anything like that would deem to be helpful. Again, though, just to add to Stephen's point, insurance is expensive, and you have to see what is actually covered, what actually is excluded, because then you can get into wrangles with the insurer about terminology. Are there going to be potentially negligence claims being brought against you? And you have to look at all around this. It's an unenviable position, and I can see within the questions there is this concern that and a real concern about, well, what can we actually do? Can we advance? Or can we actually add to Catalogue Raisonné? Can we carry on authenticating, and how can we limit that risk? And it's an ongoing conversation, and I think it's one that you will take on in terms of future ways of authenticating in your conference as well, in terms of what's a better route map for dealing with this.
Yes, and on that note, Stephen, one of the points that you had raised when we were discussing this was this new model of the Van Gogh Worldwide, for example, that wants to catalog artists' works by including all the scholarly literature and all the opinions. And I was wondering, do you think that's more protective of the authors than a traditional Catalogue Raisonné model with an authentication?
Sure. It probably is. I guess I leave to others the answer to the question: is it more useful scholarship? Is it more useful in the marketplace? Is it more useful as scholarship? Again, when you're just cataloging all of the sort of literature and other opinions, I would say the risk there is very low. But whether or not that's useful in the marketplace is a little harder to see. I think one of the things I want to just draw some maybe attention to is a distinction between what might be a purely scholarly enterprise, and maybe this is an example of it. And what we see often is that the authors of the authenticators are also players in the marketplace. You know, you have that with a lot of foundations, and a couple of situations I have now where these foundations who are the authenticators are also holders of a large number of works. And that's when you start to see the claims, certainly the claims that you saw in the Agnes Martin catalog case, where the allegations were that the Glimchers and Pace were also market makers. And so it was in their interest to, you know, to regulate the market in some way, to create scarcity in the market. And I think that's where we run into the most problems, you know. So the closer you get to a purely sort of scholarly expression of a survey of all of the sort of literature, the less risk you're going to have. And the closer you get to an organization that has an economic interest in the marketplace, the riskier I think it becomes.
That's fascinating. Do you want to add to that, either of you? Okay, I think that's pretty much, that's interesting also with the question of the authenticator and the Catalogue Raisonné, where there could
No,
be
absolutely. I mean, this is, yeah, no, I agree with Steve. It is because you have that loss of independence because they've got skin in the game.
That's right.
What is or isn't out, and then there are always the allegations about control of the market, what's being fed in, fed out, what's in, what's out, etc. And remember that some of the authenticating bodies, different jurisdictions, Chagall, for example, have the right to destroy as well. So there are other factors at play.
Yeah, I think you know, independence is really important. There's no doubt about that, but it's only one of the ingredients, I think, that lead the market to accept the view or the opinions of an expert or a group of experts or an institution. There's much more than that, and I would argue, you know, an intimate knowledge of the work of the artist is possibly, I mean, I don't know how you weigh these things, but and it's not a science. It's down to sentiment at the end of the day. But you have to weigh all these different things in order to decide, okay, this is the person I trust, or this is the committee I trust. And we have quite a few examples of an artist with more than one authenticator. And that has its own issues, as we know, but that's another topic.
I know, but that is very relevant. Somebody asked if actually you could comment a bit more on this right to destroy.
Yes.
The right to destroy the artwork.
Yeah, no, yeah, Chagall. So for example, Chagall being one, I think there's another one as well. So there are authenticating bodies where as part of the authentication process, your work goes off to that body, you sign an agreement, and if it's deemed not to be right, they can retain and destroy the work in question.
Yeah, I mean, the way it works, at least in France and Italy, the committee itself cannot destroy. The committee doesn't have the authority to destroy, but the committee has the power to call in a judge, and the judge will seize the item, and the judge can confiscate, or rather can destroy. Now, the question is, I mean, it's a huge debate, and maybe this is not the time and place to go into that, but we are seeing cases where the courts are actually looking at, you know, trying to balance the interest of the owner of the artwork and the interest of the artist or the estate. And there have been cases recently, I think Chagall is one of them, actually, where the court said, okay, the committee wants it destroyed. Obviously, the owner wants it back. Let's stamp it in a certain way so that it can't be sold as authentic. It can be returned to the owner. And, you know, it's a sort of, you know, it's to try and find a just and fair solution to a real problem.
It's difficult though, isn't it? Because there was a similar thing with the Andy Warhol Foundation, where even a stamp leaves a mark, and then there's no, obviously it's not as irreversible as destruction of the work, but mistakes or changes of opinion happen. And I know with the Andy Warhol, there were 2 documented cases where these are very old and you'll be aware, but one was authenticated, then that decision was reversed, and another one it had denied stamped on the back, which obviously was indelible. I think it might have gone through to the front of the work, and then that decision itself was reversed, so you're still damaging that work. A parallel can be seen where an artist has a right to disavow, so they might have works that are included within Catalogue Raisonné, and then for whatever reason they decide that they're going to remove that work from their body of works, or being recognized as part of their body of works, which is a sort of a parallel issue that can arise, and it may be driven by underlying commercial factors. So, for example, the deal that took place, etc. They didn't want a work to be sold at auction, so they've decided to use the authentication process as a way of removing the owner's right to then have an onward sale, or block it, or at a lesser value.
Just on a very basic level, as a scholar, I mean, what if you are wrong? That is very definitive. I would be very cautious about that. And this is another question that I'm sure a lot of people want to know about, which is the independent specialist who maybe writes a report and authenticates an artwork, but the estate has chosen not to include that work in a CR, or the CR is not including it. What about the legal value of that? I mean, does it matter who commissioned the report? I think right now we even have that Gauguin case in California, which, I mean, it's not a legal case, but it's a case where it isn't in the Catalogue Raisonné, but historians do believe it is a Gauguin. So maybe Stephen, do you want to start with that?
Yeah, I think it's a hard question the way it's framed. I mean, when you ask what's the legal value of it, I'm not sure that there's any. In terms of the legal value, it seems to me, of an authenticating body is that because it is just an opinion, right? But the marketplace respects that opinion. And so as a reality, if you are, say, trying to sell a work of art, you say go to an auction house and consign it, very often, if that work is not in the recognized catalog, they won't sell it, right? And it doesn't matter what some other person or opinion says, because they are in effect making a representation to their potential buyers that this work is authentic. And so in that circumstance, and it could be a work that's very valuable, in that circumstance, they're really being asked to go out on a limb and to not follow what the marketplace follows, but to follow some independent expert. I guess the other thing I would say is that, again, the market has a way of sort of sorting things out, but if this independent expert is one that the market is not, respecting or giving credit to, then I'm not sure what value that report actually has.
It's fascinating. Any other thoughts on that?
There are also some difficulties. I know that I've had scenarios where experts have been the key expert for a particular genre, or but a particular type of work by a particular artist hasn't been accessible to my client because they are an employee of a particular institution. So we cannot get the opinion and the valued opinion of that expert on a particular work. And that has had an impact on authenticating a work. So you have these various things, but Steve is right that it is opinion, but it carries weight within the art market, and it can be very influential both on at what level a work may sell at, and also whether a work sells at all.
And Pierre, maybe you could weigh in on the role of moral rights in this debate about authentication.
Yes, so moral rights are the rights that authors have as a matter of law They are personal rights rather than economic rights, like copyright. And the principal moral right is the right to claim authorship. I use the language of the Berne Convention. It's also called the right of paternity or the right of attribution. It's effectively the right to say this work is by me. Now, in the UK, it's available to the artist and the artist's heirs for 70 years from the end of the year of the death of the artist. But in many EU countries, moral rights, including the right to claim authorship, is perpetual. Now, one question is whether the right to claim authorship includes the right to say, this is not by me. Now, in the UK, that's not an issue because there's a separate moral right, the right to object to false attribution, which protects against any false claim regarding authorship. But that right, bizarrely, and I've never really understood why, is only available for 20 years from the end of the year of the artist's death. So the question remains, especially in countries where the right to object to false attribution doesn't exist per se, does the right to claim authorship include the right to say this is not by me? And generally speaking, the answer is yes, but there have been cases in France in particular where the court did not accept that the holder of the moral right of a deceased artist in particular knew best. The assumption, again, is that the court-appointed expert knows best. And you've also had cases where the court decided that the artist himself, who is the principal, the fundamental holder of the moral rights, the artist himself could not say that the work was not by him. There was a case in Italy relatively recently involving Jeff Koons, who refused to acknowledge that a porcelain sculpture called The Serpents. It was pretty awful, by the way, but anyway, that's just my opinion. He refused to acknowledge that the work was by him. And about 2 years ago, the Court of Appeal of Milan found that the work was in fact by Koons. And there have been other cases involving, I think, Freud and Balthus, where the court said, well, you are the artist, you say it's not by you, but we take the view that it is by you, and you have an ulterior motive for saying it's not by you. So the bottom line is moral rights are relevant, definitely, and I think they lend a quality to the authenticator if the authenticator is the holder of the moral right, but they're not the whole story. And many experts or authenticators, many authentication committees do not include anyone who has any of the artist's moral rights.
Interesting. Also, because if the artist is alive, like Jeff Koons, he simply has removed it from his website. So the artist somehow, that's the way to respond to what the judge says if he's still alive. Stephen,
yeah, but
do you have a comment?
I think it's in a way, I mean, I can understand those cases where the court says, well, you might say you're the artist, you might say it's not by you, but I'm saying it's by you. But in some way, I find it a bit strange that the artist himself is not the ultimate arbiter of whether an artwork is by him or not. There is a bit of tension there.
It's really interesting, isn't it? Because even though the court may give a judgment opposing the artist's view, it may still mean that the work isn't favorably looked on by the market, because you're thinking, right, well, if I buy this, am I going to have problems if I then want to sell it on? So you still kind of left with that problem. But it is an odd one, I agree, Pierre.
And then you get into the question of if he's alive and he's making his Catalogue Raisonné, it's likely not going to be in there. So because he disagrees. So there you are, back to the question of authentications and catalogs. Stephen, did you want to comment on that?
Yeah, a couple of things. First of all, I mean, unlike unlike Europe, the US has always had a much more constrained view of moral rights, through the Visual Artists' Rights Act of 1990. VARA recognizes a couple of moral rights, but one key distinction is that moral rights in the United States end with the death of the artist. So most of the time, when you're dealing with these catalogs, you are dealing with an artist who's no longer with us, and in which case these moral rights really wouldn't play a role. Where they would play a role would be if the artist is alive. And I mean, what we've seen here a couple of instances with certain artists who do disavow their works, and that causes confusion in the marketplace as to what value to make of them, and can they be sold, and can they be sold at auction. Katie Nolan was a sort of prime example of that. The only thing that I guess I would just also add, because it interests me, is we've encountered a situation recently, and I'll try to be discreet about it, where an authenticating body has been aggressive in trying to use moral rights of a deceased artist. This is not here in the United States, to regulate how the works of that artist can be displayed or sold. So, for example, you might have a notebook, right, created by an artist who is no longer alive. No question that the notebook is authentic, because there just isn't. But where the authenticating body says, we're not going to allow this work to be either taken apart and sort of viewed and possibly sold in its constituent elements. And if someone tries to do that, we'll take legal action against them, utilizing moral rights language in Europe. And that, to me, seems a very cusp sort of issue. I'm not sure how that would come out, but I'm interested in it.
Oh, interesting.
Was that-
What about this? I'm sorry, Amanda. Yeah.
Sorry, I was just going to ask Stephen, did they say it was derogatory treatment, the display, or?
Yeah, it violates the right of integrity, I guess,
Right.
that you would have in it. That this is not the way the work was. You're destroying it, you're altering it in a way that
Right.
fundamentally changes the work. Now, obviously, the artist is not alive, so this is a decision being made by, certain individuals.
And what about some in the chat? We have these wonderful questions about the freedom of speech, the right to censor oneself and curate one's own work by the artist. How does that factor in?
Well, the freedom of expression is now how shall I put it? In France, for many years, the court-appointed expert knew it all, and if the court-appointed expert said this is by the artist, the court would order the author of the Catalogue Raisonné to include that work in the Catalogue Raisonné. That changed about 10 years ago, when the Court of Cassation in France turned around and said, no, that's not right. If the author of the Catalogue Raisonné is of the opinion that the work should not be included, this was a female for that particular artist, she has the freedom to express herself, and it's her catalogue, and therefore courts are no longer order authors to include works in their catalogue. So that's the freedom of expression of the author of the catalogue. And I think the same would probably go for the authenticator who issues a certificate saying this is by the artist. Again, I think that would fall under the freedom of expression. Now, the freedom of expression of the artist himself or herself, I don't know if that's part of the question, but that brings me back to Jeff Koons. If he says this is not by me, who has the moral authority or the legal authority to contradict him? It's a question mark.
It's a big question mark. Now we have another question in the chat also about how these are the opinion of the heir of an artist is weighed against an expert if the heir doesn't have art history education. That's a sort of a more that's an interesting question about the quality of expertise, right?
It is absolutely, and there's going to be some. I could write a catalogue raisonné, but I know very little about certain artists. But they'd say, well, Mandy, your opinion, it carries no weight compared with somebody who's an expert in that particular artist. There are, of course, people who set themselves up, whether it's family members, associates, etc., as the authenticating person for that of that particular artist. And then I think it was Pierre who mentioned the competing catalogue raisonné or differing opinions you get as well. And it is part of that evaluation exercise. Who is the actual author of this catalogue raisonné? What is their background? Have they been a lifelong, have they been embedded and immersed in this artist's history or their development? Which again brings us back to that tension that often one of the people who's best placed is somebody who has actually dealt with their work, who has been part of their development, that knows how they've worked over many years, but then they may have this conflict of interest in terms of a commercial interest as well, and not necessarily just be an art historian. But again, it's that evaluation. And I think somebody raised a question, it was a fun one, about who authenticates the forger's work. Well, it's in exactly the same way that there are, if you look at Beltracchi, if you look at, I think someone else raised one about, it was Dehory's former associate has set himself up as an authenticator, Mark Forgy. He authenticates, he provides certificates, etc. Similarly, Beltracchi documents his work quite meticulously. He's got lots of catalogues online. You just need to have a look at his own work that he's created as his own work online, etc., to see that. So the forgers do themselves look after their own histories, have associates, etc. So it's quite interesting. There is a case, I can't find it, but that somebody had forged a forger's work. Unfortunately, if I find it, I'll share it with you, Sharon. It was a fun one.
That's fantastic.
There's another question just about just looking in the round. Courts will tend to look at everything in the round. It depends what's available. Obviously, there's not a magic machine that you put a painting in and it gives you an authentication as it comes out the other end. But they will, there's connoisseurship of the eye. There is all the scientific analysis there as well. But they all serve different purposes and they come from different angles.
Right. Of course, it's the triangulation of the three that would bring about the best result.
Yeah.
What about auction houses, Pierre? Is it really the case that auction houses and museums play no part in authentications?
Well, looking at auction houses, I would say two things. One is anyone who buys at Sotheby's, Christie's, Bonhams, Phillips, they know that the auction house gives the buyer a 5-year authenticity guarantee. And so you sort of expect that they wouldn't put their, they wouldn't risk triggering their own authenticity guarantee. And therefore, their attribution, if they say this is by the artist, you would expect that to be the case. And there is a lot of trust in their brand. And I think it's not just the buyer who would rely on that, but, the public at large. So to that extent, I think the auction houses, their word counts a lot. And the second observation is I had this case some years ago where a dealer offered for sale a work by a very important artist. He went to the 2 or 3 top experts on that artist, and all 3 said this is by the artist. So the drawing, it was a drawing, was sold as by the artist until about 2 years later, the buyer came back and said, well, I've presented this work to Sotheby's and Christie's. They won't touch it with a barge pole. I want my money back. And the dealer ended up giving the money back. And the lesson there is, whatever the experts might say, if the main auction houses won't sell it as by that artist, what is the value, the commercial value of that work?
And what about, we had a question from an audience member before about what happens when you have to inform somebody that the work is probably not authentic, and are there legal implications to that actions? Have you had any sort of cases where negative results have come from informing somebody?
No, not exactly, but I've seen, I mean, every authenticator, every committee will use a slightly different form of language, and I've seen many of these letters over the years. They will typically, I mean, if it's a Catalogue Raisonné, if it's the author of a Catalogue Raisonné, they will typically avoid saying it's not by the artist. They will simply say, well, based on my knowledge at this time and subject to more further information coming to light, it is my view that, I do not propose to include this work in the Catalogue Raisonné. So the language is actually very important.
Yes, I would love to hear more from everybody about that, because it is a horrible moment for a collector and owner to find that out, and often it leads to illegal.
Absolutely.
Yeah, and the other point, I mean, the other comment I would make on these letters is that the norm is that the letter will not provide any reason as to why the decision was made. It's either they hide behind confidentiality, or they would come up with a reason to explain, generally in one sentence, why they can't give reasons for their decision. And I think it's a wise move from on their part, because once they start giving reasons, they risk starting a debate, which can take forever, and B, by giving reasons, they expose themselves to a lawsuit on the basis that the reason they give is not good enough, and therefore it ought to be challenged.
Any catalog being advised by counsel would do as Pierre mentioned, would basically say, we now inform you that this work is not to be included in the catalog, period. I mean, words to that effect, without going to and never saying the word inauthentic. But everyone knows what it means, and the market knows what it means. So it's a little bit of a game, I think.
It's protective. It's obviously less is more, and that's very protective. And it opens, as Pierre says, you haven't got, if you're the person writing, you haven't got any points of attack or anything to get your teeth into to try and better the position. You're faced with a wall, etc. Because your client is naturally going to be disappointed, because it's affecting the value of the work. They are then thinking about, well, potentially who might I have a claim against. So there are various roads that they can then go off on that, or they may want to try and undo that position to better the position, to make sure that it can be brought back into, or reconsidered as being part of the Catalogue Raisonné. But it's that discussion that basically the authenticating body is trying to shut down with a very light one-liner.
Which can lead to a lot of frustration for not knowing why something has been excluded, I think, on the other side of it, which is really difficult. Because, I mean, if you have a medical diagnosis, you would want to know why the diagnosis was made that way. So I guess it's just a different world. But it is, most of the people I see personally are people who have been very frustrated because they just wanted an answer. I mean, maybe they would agree with the answer if they had an answer or an explanation. So it's a very different world in the art world in that case, on the legal level. We also have a question about who decides on an authenticator, who selects the authenticator, from Anastasia Tennant. Is that something that you would like to comment on? Sort of when we say the market generically, as you know, and there are other experts out there, what do we mean about who decides?
Well, there's certainly no selection committee. It's I think it's in the end, it's the market who decides based on a number of elements, such as somebody lived with the artist or worked with the artist or has intimate knowledge of the work of the artist. Independence, we talked about that. Scientific integrity, I think, counts as well. Somebody who has a reputation for integrity stands a better chance of being recognized as the expert on an artist. I mean, it's really a combination of factors that result in the market accepting a person, a committee, an institution. For example, the Wildenstein-Plattner in New York, I mean, they are an institution, or an estate as the arbiter of authenticity on a particular, of works of a particular artist.
And all
There's
those
no
factors will play out in terms of who supersedes another in terms of authority. And it can vary because reputations come and go, etc. And then you get competing claims, and there is a deciding factor about who is the one that's going to take priority over the other in terms of opinion. But it doesn't necessarily always iron everything out, but you end up with the issue of competing claims. But it pretty much is the market that decides those factors.
And not every artist has a recognized authenticating body or catalog, and in which case then it's again, then it falls more to auction houses, galleries to do the due diligence to try to decide whether something's authentic, but it's not one catalog. Whereas in some cases, again, if it's not in that catalog, it's not authentic. It could be, but in terms of market value, it's not really sellable at the moment in time. And we know from history that scholarship changes, and a lot of the major catalogs, works are in and then they're out, or they're out and then they're in, and so it changes. And when you buy something at auction, as Pierre said, they're giving you a 5-year warranty of authenticity. It's even less, if you buy something, say, just in New York, and then basically that guarantee is good for 5 years, because everyone knows that it could be different in 10 years, 20 years.
It's just inevitable risk, right? In terms of, yeah. Okay, we have somebody asking if what's the best way to react to a negative opinion in case this is based on a very cursory examination of the work, like photographs or something like that. And maybe Amanda, you could take that up, because you were speaking about in our discussion before certain, certificates, golden certificates that in the end don't hold weight.
Oh, absolutely. So it sounds here, it doesn't sound like a considered, the scenario here just seems to be like somebody's just given an initial look rather than a proper opinion or a written opinion in any detail, nor does it really allude to a catalogue raisonné. So, I mean, that could be contradicted by another opinion, which is the opposite. Something is detailed and studied, etc. I would say. Here it just sounds it's just an opinion given on the cuff, as it were. So it's worth exploring. It's quite difficult to. I think you need a bit more in terms of the facts. Decision not to include the work in the CR. Okay, yeah, fine. Okay. That's slightly different in terms of it. I'd be asking why, and trying to probe a bit more about that. In terms of that, particularly in relation to photographs, and any other independent research the person can do in opposition to that opinion would be helpful. If there's a body, if you can put together a body of evidence to contradict that opinion and say, well, here's a picture of them actually taking the photograph, that kind of a thing would be helpful in contradiction to something that you believe is slightly a flip judgment. I talked about just briefly on certificates of authenticity. Again, it depends who's busy creating these things. All of us would have seen certificates of authenticity that really aren't worth the paper they're written on. And they might have on lovely paper or watermarked, all the rest of it. But if they are generated by a gallery that hasn't touched those works, or has only recently touched those works, it's got no proper connection, they can't, then are they really in a position to authenticate? Probably not. I've also seen them used where the work in question is not authentic, but maybe the document itself is authentic, but the two things have been married up together. Think of Beltracchi, talked about Beltracchi, all that provenance documentation, photographs, etc., that went behind it. But the works themselves are fake, so it's marrying original documentation with a fake work. Or a certificate of authenticity really is nothing. It's a nothingness. It doesn't really prove anything. So you have to be very careful. I'm quite allergic to certificates of authenticity. I'm always very suspicious when they are the first thing that's being wheeled out as proof of authentication.
Fascinating. What about conditions of an artwork? Can you be sued for putting conditions of an artwork in a Catalogue Raisonné? That's a question we had from an anonymous person registered, because you could risk devaluing it by describing its condition.
Well, I think potentially yes. I mean, it depends. Obviously, if the condition report or the description of the condition in the catalogue is accurate, I mean, then we can have a debate as to how much is subjective and objective. But if it's the result of a physical inspection and the description of the condition is, in inverted commas, accurate, well, I think probably, I mean, you can always be sued, but you know, the outcome should not be a bad one for the author. But you know, if the author is not careful, has not inspected the item personally, relies on hearsay, or does a botched job, if I were the collector owning this work, I would certainly be very upset and you know, take legal action if I can afford it.
Any thoughts on that?
Sorry. I mean, I've never seen this come up here, but the one thing I can say is, unlike authentication, in that opinion, you know, condition is discernible by, you know, participants in the market. So, I mean, and one doesn't necessarily know what condition something's going to be in subsequent to it being entered into a catalog. But you know, whatever one might say about condition, when you see the work itself, if it's in the market and you're going to buy it or not, you can confirm what the condition is. You know, that's observable, as opposed to whether or not it's authentic, which is much more complicated.
It's quite an odd. I've not seen condition come up, but I'd be very careful about that, because also, what hat are you wearing? Unless you're a conservator, would you want to be advancing that opinion? Or you know, already we're faced looking at the questions. Everyone's concerned about advancing opinion on authenticity, let alone also about adding to it in terms of condition. So I'd be very careful about, if you're not a conservative, that's not your field of expertise, what you actually advance or include within this document.
Yeah, I would agree.
That's amazing. That is because, I mean, you know, you always should also have an independent conservation report, because clearly things can be cleaned up before there, and maybe it's not visible to the naked eye. What parting remarks would each of you have for to close off this wonderful conversation? Sort of what advice would you have for our audience about Catalogue Raisonnés and authentications, or versus authentications? Anybody like to take that up? Sort of the best case scenario maybe of Catalogue Raisonné married to authentications, or this idea that you proposed earlier that maybe they should be separate issues, separate spaces, one more for the market and one more for scholarship.
I think it's an evolve. We can see what the problems are for those on all sides, because you have a document that's or documents or bodies of work, bodies of research that can be used for a commercial purpose. And that's where the liability typically arises, because you've got the meeting with the art market. And I think there is a discussion to be had about how this has moved forward in terms of looking at works, and also what is the purpose of a catalogue raisonné? Is it to be purely about documenting an artist's work, or does it have a wide, what is its wider purpose? Is it a fixed static document? So if you have a hard copy, boof, here we are, Catalogue Raisonné, that's slightly different, and the position is slightly moved on now. If you think about digital approaches, ways of reframing it to say about mapping an artist's work, does that really change how a Catalogue Raisonné is going to be used, or does it really not? Is it just relabeling the tin, and people will still be bringing claims to say you weren't included in the map Catalogue Raisonné of this particular artist? But I think there has to be a more of a holistic approach, because there are advances on things is more fluid now, in the sense that the Catalogue Raisonné can be updated digitally, or things can change in more sort of real time without publishing restrictions. Similarly, there are other advances in terms of tracking from artist to all the way through, in terms of what actually forms the body of their work. So different changes. So I think there's a fluidity that's worth exploring, and also how they're going to be used in the future. But at the same time, we have to look at how to protect those that create. And I think there's work to be done within the community, a discussion to be had about how best to protect those that do operate in this area. That's certainly in my jurisdiction not fully bottomed out.
Yeah, okay.
I still come back to, if you're an author and you're here in the United States and you're in the position of receiving works to evaluate, that the submission agreement is still very key. And again, your legal risk, I think, is actually relatively low, because you're expressing an opinion about a work of art. But because we are in a society here which is a bit litigious, and because sometimes those individuals have the resources to do that, and a reason to do it, then having that agreement that says, among other things, that if you take me to court and you lose, you're going to pay my legal fees, and those are enforceable. And I think that's a deterrent, for that kind of litigation.
Yeah, that's an excellent point about sort of the agreements, looking at your agreements as scholars as well, or authors of Catalogue Raisonnés and authenticators, and making sure, yeah, that those things are covered, because it can get quite expensive. Pierre?
I am fascinated by by what technology and AI can do and will increasingly be able to do for authenticators and authors of Catalogue Raisonnés. I would encourage everyone to have a look at a lot that Sotheby's sold in July, on the 20th of July 2023. It's an original printed card with manuscript notations by Buzz Aldrin, not sure I pronounce his name properly, who was the second man to walk on the moon during the Apollo 11 mission. And the reason why this is so interesting for me is because the auction house has used what they call mirror image, which is a form of microscopic 3D scanning technology that extracts the DNA of an image and turns it into code. And the reason why this is amazing is because if you for example you have your certificate of authenticity and you turn that into an NFT that you attach to the blockchain, and you incorporate this image DNA in the certificate, not only is your certificate really safe, it can't be lost, it can be, manipulated, but also you know that at any point in time you can match the certificate with the work. In other words, you presented in Amanda's example, you're presented with a certificate that doesn't match the artwork. Well, you take a mirror image of the artwork that's presented to you, and you extract the DNA of that image. If the DNA of that image is the same as the DNA that's on the original certificate on the blockchain, you know you're looking at the same work. If the DNA is different, then you know the work is not right. And this is the sort of technology, technological development that I find so extraordinary. And I think, in 10 years' time, we'll have a completely different conversation around authenticity and Catalogue Raisonné.
Well, that's a beautiful way to close it, with a glimpse at the future. And it's so wonderful to have three such, I don't know, amazingly profound and sort of far-reaching minds. So thank you, the three of you, for being with us, and thank you for all this audience with the incredible involvement in this conversation that has gone on for the last hour and also before. We hope to see you all at our conference and hope to have more conversations in the future.